seated. All right, I did receive a rough draft of the jury instructions, which I did review. Do you want to do our charge conference first or something else?
I would like to do the process first.
All right, let's do then let's do that. What's the name of the witness?
Joseph Salerno.
You can please approach the witness stand, and when you get there, remain standing and raise your right hand to be sworn in, please.
Do you solemnly swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
You may be seated. Can you please state your full name for the record?
Joseph Salerno.
Can you spell both first and last, please?
JOSEPHSALERNO.
All right, you may proceed.
Thank you. Good morning.
Good morning.
Where do you work, sir?
Plantation. City
How
of Plantation.
And what do you do for them?
Road Patrol.
How long have you worked there?
Since 2016.
Okay. You actually were involved in the murder investigation that commenced on October 5th, 2017, regarding Eric Robinson and Isabella Tagliarini, correct?
Correct.
Your role in that was minor?
Very minimal.
Okay. A few weeks before that, did you have the opportunity to go to that same house where the incident is alleged to have occurred?
Yes.
Do you recall who went with you?
Officer Bruto, I believe.
Okay. Can you tell me about what type of call it was that you responded to?
Domestic argument.
Do you recall who the caller was? And if you need to refresh your recollection, just let me know. I know you have a copy of your report.
Is that okay?
Can you refresh?
Yeah, you can refresh your memory.
Thank you.
Is your memory refreshed?
Yes, sir.
You may answer the question.
Nicholas Wilcox.
And he called for assistance with regard to an incident that was ongoing with his girlfriend at the time, Isabella Tagliarini.
Correct.
What occurred, or what was happening when you responded?
When we got there,
Yes.
there was items that were smashed inside the house, and we were advised that there was an argument between them.
Okay. Do you recall injuries also to a vehicle?
I can't say I do.
Okay. And Mr. Wilcox told you that he was frightened,
Yes.
and Ms. Tagliarini appeared to be intoxicated.
Very much so.
She was belligerent,
Yes.
uncooperative,
Very.
and because of that and what you had been told had transpired inside the house, you had asked Isabella Tagliarini to vacate the residence for at least the night.
Correct. So that they could calm down and stay separated, so nothing further would escalate.
Okay. And she did that?
Yes.
Did Ms. Tagliarini, your report indicates that she had stated she was very upset with him over personal matters. Do you recall what those personal matters were?
No.
Okay. I have no further questions. Thank you.
Any questions
Nope.
from the state?
All right, officer, if you can step outside and just wait pending further instruction.
Yes, sir.
All right, thank you.
Thank you.
Ooh, careful. Everyone in the country just saw you do that. Okay. Any other witnesses? Okay. Argument, if you want to make your same argument. Again, I really don't see the relevance. It's a different allegations, prior bad acts. Even in terms of similarity to the crime, even if this were a Williams rule hearing, I think I would still exclude it because it's not. This was a argument where the only actions were a car got beat up, not a person. So I don't find that it's relevant, and it's more prejudicial than anything. And you've made your record, and I am standing by my ruling that the testimony is excluded.
May I excuse officers?
You may.
One additional argument I didn't realize he had with regard to what just occurred.
Okay.
Your Honor, I have a case, Nicholson v. State. It's a fourth DCA case, 10 Southern 3rd 142. I'll hand my only copy to the state.
We have a copy.
We do?
Yep.
Can you tell me what the fact pattern was in that?
In this case, Your Honor, it allowed for, it had to do with collateral crimes, where basically there was,
Your Honor, you want me to print you a copy?
That would be helpful. Yes.
And I think I read the case, and I believe it deals with the defendant's domestic priors that were alleged.
So if I were literally to take it at face value, I should probably reconsider the state's motion to let in the prior domestic violence?
Your Honor, it has to go, well, this has to do with motive. What happens in the Nicholson case is the only point that is made in this case, and I'm bringing to the court's attention, is that if it has to do, if it's motive, that the similarity requirement is not.
Well, let me put it this way. As I understand the case and the argument that you're making, that's probably more helpful to the state than to the defense because of the prior domestic violence alleged against Ms. Tagliarini. But I do also feel that it's not very strong as far as motive. And again, the facts are dissimilar enough and remote enough in time that I don't find that it's, I do find that the prejudice is much greater than any probative value. So I accept your argument. I do disagree as to its applicability to our fact pattern. And you laid your record, and I stand by my ruling denying admissibility of the prior incident where Ms. Tagliarini had an argument with the decedent and beat up the car of the decedent, but not the decedent himself. So I've ruled. Give the state an opportunity to address that motion. If the state wants to put any argument on the record, I'll give you that opportunity.
Judge, I know we had the testimony of Isabella Tagliarini, and one point of contention is obviously her actions during this whole scenario, that being not calling the police, not reaching out to anybody at the Publix or at the Big Lots when she had the opportunity to do so, because obviously she had a cell phone, not to mention the fact that she was holding hands with the defendant and hugging and things like that. So as it's presented to a jury, that might come across, I'll use the words odd, but I think if you put it in context of the fact that she was subject to domestic violence, and we have witnesses that can testify to the very fact that Eric Robinson did beat her, and this was witnessed by Ms. Ginsburg outside of the home, I think it puts her actions within context. So at this point, it's very much out of context, I'll say, as it's presented to the jury. She would testify it's because of, you know, the abuse that she was subject.
I'm sorry, I don't mean to interrupt, but what's happening right now? You asked the state to then now ask if they can get.
I'm not telling the state to do anything. When someone makes a motion, the other side usually is allowed to make their argument.
Make a motion. I just was doing the proffer because the
Well,
motion.
the proffer was in conjunction with your attempt to introduce.
But it was already settled, which was the point of the proffer.
Well,
Your Honor already excluded it.
I gave you an opportunity to make your proffer, so you can have an argument, which I thought you just did, and about why it should be admitted. And so I'm giving the state, because if in case there is appellate review, the state has a right to make their argument. So I'm giving them the opportunity.
Okay, it just sounds to me like the argument is not a response to whether we should be able to get in Ms. Tagliarini's incident with
If
the
you like, Ms. Newman, I will give you an opportunity to make a rebuttal argument when the state is done. So let's do it one at a time.
I just feel that we should be able to get into, not all domestic, but at least put her testimony within context, Your Honor. Specifically talking about, there's a video that we have that was taken by Ms. Tagliarini in early August, I want to say. I can get the exact date for you. Where the defendant is assaulting Ms. Tagliarini, puts his hand on her mouth, preventing her from talking, and on numerous times during the incident, he says if she doesn't shut up, he's going to kill both Nicholas Wilcox and her. He says multiple times that he's going to kill her if they don't shut up.
Rebuttal argument?
Am I understanding the state's asking, Your Honor, to now let in the domestic violence between Eric and Isabella?
That's what it sounds like to me.
That nothing has changed since the beginning of this case. I was very careful on cross. I never asked her why she didn't call the police. All of the testimony about her bizarre behavior is attributable to herself and to the state's direct. I made no mention of anything. I kept it very clean, so I don't think anything has changed. I don't understand this. This has nothing to do with what just happened today, but fine. But I mean, again, I didn't voir dire on it. It was kept out. It's been kept out. All of my crosses have been, because it's out, I haven't asked questions about that. And so I don't know if the state's saying I opened the door. I understand that they wanted in to try and explain Ms. Tagliarini's bizarre behavior.
I think the state is sort of piggybacking your argument for admissibility of this type of evidence, and it cuts both ways. So
a specific act between the deceased and Ms. Tagliarini, which I'm alleging goes to motive, is not related to this. I thought this was a settled issue. Obviously, the state can bring up whatever they want at any point. I'm not saying that, but nothing about her testimony yesterday opened any door. I've been told repeatedly, be careful, be careful. Mr. Sapak is the one that asked her probably 6 times every time he showed a video of her with, why did you call the police? Why didn't you call the police? Why didn't you call the police? Because he knows that's a problem with his case. And she kept saying, because I was scared, because I was scared, because I was scared. So I stayed away from that intentionally. I stayed away from the minefields that I knew I had to stay away from. So.
Both sides done with their arguments, so I can rule? Okay. I stand by my previous rulings to the extent that the evidence sought against Ms. Taglerini and Mr. Robinson has probative value. I do find that the undue prejudice is greatly in excess of that. As to Ms. Taglerini's reasons for behaving in the manner in which she behaved, she did offer an explanation as to her fear, and if she is believed, I would believe that the acts that she witnessed, as she described, of the murder of Mr. Wilcox would be sufficient to cause that fear. So I don't find that the prior domestic violence adds that much more compared to the undue prejudice of allowing other acts of violence of the defendant. And as to Ms. Taglerini's arguing and hitting the car of Mr. Wilcox, again, I find that it doesn't really establish a motive, and again, whatever probative value it would have is greatly outweighed by the undue prejudice. So I'm not admitting it. So I stand by my rulings.
Sorry, the printer was on the fence.
Okay. Review it and hold on to it. Okay. We ready to start our charge conference, or is there something else I need to address? Okay. Before I forget, there is one issue I want to give a heads up to the lawyers on. One of our jurors left a message in my chambers that apparently they forgot, or he or she forgot, that their child has a high school graduation on Tuesday. I had my JA leave a message to that we would discuss that tomorrow.
Okay.
So just to give you the heads up on that. Okay, are we ready to have our charge conference?
Yes, Judge.
Okay, and if I didn't say it, let the record reflect the defendant is present with his counsel and counsel for the state as they have been throughout all the proceedings this morning. Defense ready for our charge conference? Ms. Newman? You are the defense, right? Okay. Okay. Okay, let's go through the packet. When we do our final draft, if it is my preference not to have page numbers on the bottom, that way if we have to move things around, we don't have that issue.
And Judge, I have them on the computer, so I'll make the changes as we go.
All right, great. All right, after the title page, Introduction to Final Instructions, that is a standard, and I'll read it as is. Statement of the charge, that appears to be correct. If the defense takes issue with anything, please bring it to my attention. Next, Introduction to Homicide. Both sides agree that it should be read as is.
Yes.
Okay. Next, when there are lesser included.
Justifiable and excusable, right?
Or you keep them in. That's the standard. Okay, thank you.
Well,
Forget it.
my understanding on the justifiable and excusable is that there, at best, there may be conflicting case law as to whether or not that's waivable. So I agree that if the defense wanted it out, I would put it out. However, in light of conflicting case law that was brought to my attention in another case, I'd rather be safe than sorry, so I'm going to leave it in. At best, it's harmless.
On the second page, it says murder in the second degree with a firearm, and we change that to a weapon.
Yeah, we changed it.
Okay, that's good that we're having this so we catch these mistakes. So you'll change firearm to weapon, or deadly, actually, is it deadly weapon? 'Cause I think is that what's alleged in the information? Just wanted to track the charging language.
With a weapon, bludgeoning him with a weapon and/or unknown hard object.
So it just says weapon. Okay. Now, as to the lesser included crimes or attempts, are the parties on both sides seeking any lessers?
Yes, Judge.
Okay, and the instructions includes manslaughter.
It should be manslaughter with a weapon, Judge.
Okay, manslaughter with a weapon. So you'll make that correction. Anything else that's being sought as a lesser that's applicable from either side?
Yeah, I'll let them know.
All right, you're still thinking about it? All right. Just do it as, once you make that decision, let us know as soon as possible so we have time to make any corrections that may be needed. Okay, let's moving on. The definition of second-degree murder. Let me just read it out loud and see if both sides are in agreement. To prove the crime of murder in the second degree with a weapon, the state must prove the following three elements beyond a reasonable doubt. 1, Nicholas John Wilcox is dead. 2, the death was caused by the criminal act of Eric David Robinson. 3, there was an unlawful killing of Nicholas John Wilcox by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. And then there are definitions. The definition of an act, which includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of murder in the second degree with a weapon, it is not necessary for the state to prove the defendant had an intent to cause death. The next paragraph is an issue in this case is whether Eric David Robinson did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation. In order to find the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation. A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. And B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And C, there was not a reasonable amount of time for a reasonable person to cool off. And D, a reasonable person would not have cooled off before committing the act that caused death. And E, Eric David Robinson was, in fact, so provoked and did not cool off before he committed the act that caused the death of the victim. If you have a reasonable doubt whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should not find him guilty of murder in the second degree with a weapon. Both sides agree that instruction is correct? All right. Let's discuss the lesser included offense of manslaughter, which is the next in the packet. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Nicholas John Wilcox is dead. 2, and there are 3 options. You're just going under A. And A reads, Eric David Robinson intentionally committed an act or acts that caused the death of Nicholas John Wilcox. So we'll delete B and C. Every person has a duty to act reasonably toward others if there is a violation of that duty without any conscious intention to harm. That violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only that an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Both sides agree to the instruction as I read it. Okay. And state will make those, Ms. McGuire, you'll make those corrections. Okay. Then there's the principal instruction. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if, yeah, I think that should be he or she. Had he or she done all the things the other person or persons did if, 1, the defendant had a conscious intent that the criminal act be done, and 2, the defendant did some act or said some word which was intended to and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted.
I'm asking for this instruction to be
Well, if there was only one person involved, I would agree with that. Is the state asking for the principal instruction?
There's no evidence that he assisted her in any way with a murder.
It's very rare, but I tend to agree with this. The defense in this case, Judge.
So you're not asking for principals, okay?
Well, I mean, I would be asking for it. I just don't think it's applicable with the facts that we have at the moment.
Well, okay, so right now you're not asking, but you're reserving the right to ask for it later?
Can I just do a little research, Judge? Because my concern is if it's not charged in the information, are we entitled to it in the jury instruction? I just wanted to.
I don't think that that's something that has to be charged in the information.
From that point of view, it has to be based on facts.
I just
charged.
From that point of view, it doesn't have to be listed in the information.
Correct.
That's correct. But just the trial's not over. We don't have all the facts yet, so I'm going to reserve as to principle.
All right, that'll be another decision that we make right before closing arguments then. All right, the next instruction deals with aggravation of a felony by carrying a weapon other than a firearm. Yes, go ahead. You were going to say something?
No, if you can read it.
Yeah, I'll read it. If you find that Eric David Robinson committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of murder in the second degree with a weapon and manslaughter with a weapon.
Which number instruction is this?
That is on page 12 of the rough draft.
I mean, because I'm just matching 3.3. 3.3.
B.
Thank you.
You need me to wait a second, Ms. Newman?
No, it's okay. You can use it.
Okay.
Thank you.
A weapon is legally defined to mean any object that could be used to cause death or inflict serious bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Eric David Robinson committed second-degree murder, it should say or because they're not going to convict of both. So it should read or on that, and it should, in the first paragraph as well, it should say or. So change the word and to the word or between murder in the second degree and manslaughter. Okay, let me read that last paragraph. If you find that Eric David Robinson committed second-degree murder or manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of murder in the second degree and manslaughter.
I can find this instruction online. It's reserved on the website, and the language in 3.3a is actually different when it defines weapon here. So on the current version,
My book. What number is it again? The 3.3b. differences in the definition of weapon.
I thought it was just the word legally, but it's actually,
No, there's
yeah.
there's more. It's close, but there are differences. Was there an amendment of this particular instruction? Because I'm trying to figure out where you got this from, or is this an older instruction?
Odds are good, Judge, it's just a packet that keeps getting,
It says 2016 on the front, and
well, that's, I don't even know why there shouldn't be.
Well, if the defense wants us to go by the book, we'll go by the book. So let me track. Let me read what's in the book. A weapon is defined as and in the instruction is it says legally defined, which
it's the same as the one in 3.3b, though, right? Because that one, Ms. McGuire can pull up and just copy and paste
The
it.
only, I mean, I'm just looking to see if there's, I am, but I don't see any amendments made to it since 2011, so I don't know why it says that on the website, but, or I mean, it says reserved, she's right about that, but I don't see, let me see. I can just use the,
well, it's easy enough to amend it to add in the missing words.
Why don't we just track the language from the Florida Supreme Court website?
yeah, but it's the 3.3A instruction.
Well, let me read what I have, and if you have something different, please tell me. We start from the beginning. And there are corrections that need to be made there as well. If you find that Eric David Robinson committed murder in the second degree or manslaughter, you omitted that. So from that sentence. Let me know when you're ready for me to continue.
I'm ready.
And you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a weapon. You should find him guilty of murder in the second degree with a weapon or manslaughter with a weapon. So that's the first paragraph. The second paragraph is the definition of weapon. I'm going to track the language in the book as to jury instructions. A weapon is defined as Ms. Newman, you want the numbers read, or you just want it as a regular paragraph?
I'm fine with it being a regular paragraph.
Okay.
Or in the middle.
Okay, then a weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used. I don't think we need to put threaten to use because that's really not applicable. That was used to inflict bodily harm. So it's really almost identical, but a couple of words changed. You with us, Ms. McGuire?
Yep, I'm just gonna,
Let me know when you're ready for me to move on.
a weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm.
Okay. All right, in the last paragraph, if you find that Eric David Robinson committed second-degree murder or manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of murder in the second degree or manslaughter. And let me ask this question before we move on, because the actions portion of it are all bracketed individually. So you put it in there as applicable. Is either side asking for threatened to use or attempted to use to be in there? Because that's either he did or he didn't, as I would assume. Because there were no verbal threats or any words said before the action that were directed toward the victim. Just makes it clearer, I think, if you don't have, if you exclude inapplicable portions.
So I would get rid of,
Threatened to use or attempted to use. So it would end up being that he personally carried, displayed, used a weapon, or it should be or used a weapon. Then you should find him guilty only of murder in the second degree or manslaughter. Actually, this is the aggravation instruction. So the last two things should be with a weapon. So it should be either guilty of only murder in the second. Oh, actually, no. Scratch that. That's if they don't find a weapon. Okay. So that last paragraph now should be correct. Okay. All right, we're ready to move on from that instruction. Right, next is plea of not guilty, reasonable doubt, and burden of proof. I'll read through it real quick. It should be pretty much as is. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation actually it should be information, correct? There was no indictment in this. So let's change that. Glad I read through it. Okay, each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crimes with which the defendant is charged were committed and the defendant is the person who committed the crimes. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflicts in the evidence, or the lack of evidence. If you have a reasonable doubt, you must find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Okay, that seems to be correct.
The second paragraph, crimes plural, can we take out the plural, committed the crime?
What, you want it just singular?
Yes.
All right, I think grammatically that would be correct. So let's make crimes singular, so it should read crime. Okay, evidence of other crimes, wrongs, or acts. Well, there really wasn't Williams' rule presented. Is the defense asking for it?
No.
Okay, then let's keep that out.
Well, hold on.
Okay.
I'm sorry.
I mean, the only...
No, I'm thinking of the jail issue. I might ask for a special on that. But
Well,
I don't have it.
then if you are, please provide it to me. It should be something to the effect that it has no legal significance and you are not to consider it in your verdict, something to that effect. Provide that to me and I'll put it in there. But sooner the better. Okay, so that the evidence of other crimes, that's gone. Next, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? I think those 5 get read. Let's discuss the next 5. 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? This defense is asking for that?
Yes.
Okay, I'll give it. 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Defense is asking for that?
No.
No? state asking for it?
No, Judge.
Okay, so 7 gets taken out. Okay, so 7's gone. Number 8 is, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Okay, then I'll give it. Number 9, has the witness been convicted of a felony or of a misdemeanor involving dishonesty?
I would ask for that in lieu of Isabella. I know she hasn't been convicted yet, but she did plea. And
Well, then that is not applicable to her yet. And anyway, you're covered by number 6 on Isabella.
and reserved as to Eric, of course.
Okay,
We still haven't gotten into that.
right, if I take it that the defendant is a convicted felon, is that correct?
Well, Your Honor still hasn't
Yes.
ruled on that.
He is, but it's from, I think it was like 12 years ago, so I had provided 20 years ago, I'm sorry, 20 years ago. And so I don't believe, correct me if I'm wrong, everyone, but I don't believe Your Honor ever ruled on that.
Well,
So,
I should be ruling on it.
no, we got a withhold on that one. Yeah, he got a withhold on that. That was part of my argument as well, that it was so remote for that. And then Judge Bober said, well, that's a different argument. But then we kind of tabled it because it wasn't important for jury selection, because I said that I wasn't going to address it in jury selection. So we can address it at a later time, but
We had county, because there's other county stuff that we had to order the certs for, so.
yeah, it was one case up in Volusia, I think, or something.
So you want to address that today, or you want to hold off on that decision?
I haven't seen the documents. I guess the state was pulling certs, I think, is where we were last time, so.
I'll provide it to the defense. We have it, Judge.
All right, I'll hold off on number 9, but at some point before the defense puts on its case, I do need to make a final ruling on that issue.
Right.
Okay. And I don't believe there's been any testimony about anybody's reputation. Is that correct?
There's no reputation.
So 10 does not get read. So number 9 is a maybe. And 7's gone. And so what we're going to do when we do the instructions is number 8 is going to become number 7, since 7 was omitted. And if it ends up being put in the packet, number 9 would become number 8. But for now, I'm reserving ruling on that issue until we've had an opportunity to fully argue it. Okay. Whether the state has met its burden of proof does not depend upon the number of witnesses called or upon the number of exhibits offered, but instead upon the nature and quality of the evidence presented. That stays in. Law enforcement witnesses, and when we do our final packet, all these little headings will be taken out. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of other witnesses. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. And then we have accomplices and informants. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime or has been promised immunity from prosecution or hopes to gain more favorable treatment in his or her own case may have reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt or the other evidence in the case does so, then you should find the defendant guilty. So, defense asking for that?
Yes.
Okay,
And
then.
if that's the case, then we'd like principal to be in, because Ms. Newman's argument on principal was that it's either Mr. Robinson committed the crime or he didn't, and there's been no allegation that Isabella helped him or was an accomplice to him actually committing the crime.
She's charged with accessory.
She is, but she's because of her
It's
actions after. It's not
not-
during the commission of the crime.
What the charge is not the driving force behind whether that gets read or not. The issue, and it's, just from what I gathered from opening statements, state is pointing the finger at Mr. Robinson as being the killer. The defense is pointing the finger at Ms. Tagliarini. The evidence would suggest that both parties were present at the time of the killing. And so, which leads to the next question of there being a third possibility. That possibility circumstantially could be that both of them did it. I don't know what the jury's finding of fact is going to be. My job is to give them what the law is. And that is the law and principles is accurate and is something that may be considered by them in deciding whether or not the two parties acted in concert with each other in the murder.
I disagree, but I think case law will be pivotal on this. A principle, I understand what the court's saying. that
Look,
the jury-
if you have any cases that say that you cannot give the principal instruction when the person that you are alleged to have been working with was not charged with that crime, I'll consider that. But at this point, in absence of such case law, I do believe that circumstantially that instruction can be given. So if the state's asking for it, I'm going to read it. I don't think it's there's any legal reason why I should not when Ms. Tagliarini and Mr. Robinson, at least circumstantially, were both, according to the testimony, taken the light most favorable to the state. That there's evidence circumstantially that both were present at the time of the killing.
Right,
So
there's no legal reason not to give it, and I disagree. I think there's every legal reason not to give it. I think for starters, it's going to be...
Give me some legal authority why I should not read it, and I will consider it.
Okay.
But at this point, in absence of that authority, if the state's asking for it, I'm going to give it.
Right, I just want to say it's the way, it's not what the jury can decide based on the facts presented. It's the way the case is charged by the state is what would define the instructions that Your Honor should give. And if they're charging Mr. Robinson as the killer...
Give me authority that says that if it's not charged in the information, I can't read the principal instruction. And I won't read it if you find a case that says that.
Yeah, Judge, the case that says you can is State v. Roby. It's a Supreme Court case from Florida, 246 Southern 2nd 566. I will print out a copy for everybody.
Okay, great. I mean, that's my understanding of the law. If you find something that shows that I am wrong, Ms. Newman, I obviously will follow the law.
Right, I mean, this is a 1971 case, so I don't want to, can we do the argument
Well,
tomorrow?
until it's reversed, it's good law.
I just haven't had an opportunity. I thought we were researching this and you were open to it, and Mr.
I am open to it.
I mean,
I'm not giving the instructions today, so you have at least a couple days, probably the weekend as well, to do your research. And as long as you get it to me before closing arguments, then that's fine. Okay, I'll wait for the cases to be distributed, and then we'll move on to the next item. Okay. Thank you. Okay. So, subject to revisiting, should the defense find some case law, for now, I would give the original issue was whether I was going to read the paragraph on accomplices and informants, and I am going to read that. If the defense does not find a case saying that I should not read it, I will read the principal instruction. All right, the next item is if the defendant testifies, the defendant in this case has become a witness, you should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. If he testifies, I'll read that paragraph. If he does not, then we'll take it out. And that the reverse holds true for the defendant not testifying a portion of the previous instruction. Okay, witness talk to lawyer. I'm inclined to give it. And you may rely on your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. So I'll read that. Here's the defendant not testifying. If he ends up deciding not to testify, would the defense be asking for both paragraphs? And first paragraph, okay, well, some people don't. And just so it's clear what it is. First paragraph reads, the Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The second paragraph reads as follows. The defendant can exercise a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did not take the witness stand to give testimony in the case. So if it ends up that he does not testify, I will give both paragraphs. If he does testify, then we'll delete that instruction. Next, defendant's statements.
There's no defendant statement.
So you are not asking for that, is that correct?
No.
I mean, there were no defendant statements to law enforcement?
Correct.
Okay. Okay, eyewitness identification. Is that something that either side, that instruction, is that being requested by either side? I don't think this is really an ID case, but, I mean, I could read it if you want it.
Actually, I would ask for, because of Christina Ginsburg.
All right, then I'll read it. Because she saw him from at night,
Yes.
so I guess her ID is being put into question by the defense. So I'll read it. All right, rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Everyone okay with that instruction as is? Okay. Next is the cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Agreed that that's good as written? Okay. Next, the verdict instruction. You may find the defendant guilty as charged in the information or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary forms of verdict have been prepared for you. They are as follows. So those 3 paragraphs are good as is? All right, I have a proposed verdict form. Has the name of the case on top. We, the jury, find as follows as to the defendant, Eric David Robinson, in this case. Check only 1. A, The defendant is guilty of murder in the second degree with a weapon as charged in the information. What happened to B? We go from A to C, so what happened to B? So C becomes B and, okay. I mean, normally, well, actually, what we normally do, the way it's done, is on A, you would normally put the defendant is guilty of murder in the second degree as charged in the information. The question regarding whether or not he had a weapon, that's what the interrogatory is for. Just like if this were a robbery case, you would have A being guilty of robbery, and then you would have the interrogatories to decide whether there are any enhancements.
Okay, so the defendant is guilty of murder in the second degree as charged in the information.
Right.
Okay.
And then you have that's why you have the interrogatory. And the interrogatory reads, you must answer the following question. During the course of the crime committed, did the defendant, Eric David Robinson, actually carry, display, use, threaten to use? I think threatened to use or attempted to use, you can take that out because the facts don't support that. So it would be that did he actually carry, display, or use a weapon? So you have to put the word or before use. And it's a place to mark either or check either yes or no. So say we all, this blank day of April, actually, by the time the jury gets the case, April's going to be May. So you might as well type May in there. Any other corrections, Ms. Newman?
No.
Okay, so those changes will be made, which leaves us with submitting case to jury, which reads, in just a few moments, you will be taken to the jury room by the court deputy or bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court bailiff. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court bailiff while you deliberate. If you need to communicate with me, send a note through the court bailiff signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open courts. And there's a portion that I give if applicable. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when we begin to deliberate. Okay. And then there's the other option. If you wish to see any exhibits, please request that in writing. May have to do a sort of a hybrid here. I would.
Some of the exhibits will be sent to the jury.
Right. When you begin to deliberate, if you wish to see any exhibits that were not sent into the jury room, please request that in writing. Got that, Ms. McGuire?
Yes.
All right. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. All right. Everything's okay with that instruction as amended by the court?
Yes.
Yes, Judge.
Okay. Well, I think that really leaves the defendant testifying, not testifying portion, whether or not the jury gets read the felony issue regarding rules of items to consider. The defense was going to do a paragraph or an instruction dealing with the fact that it came out that he was in jail. Please prepare that and send a copy to the state and to the court as soon as you can, Ms. Newman. State, assuming that you have no objection to her paragraph dealing with the jail issue, which I've stated gave you a rough statement of what I would read. What I want is to incorporate it within the jury instructions, either as a separate instruction, or if the parties agree that it should be tacked on to one of the other existing instructions. That's okay if the parties are agreeing to it. If there is not an agreement, then I will decide.
Very well.
Anything else that we need to discuss this morning?
This case, Judge.
All right, then tomorrow morning, 9:30 then?
Yes, Judge.
All right, I'll see you then.